can I get you back to a question Justice Thomas asked, okay? And in part that Justice Kagan did. I have some hesitation doing away with the Rogers test because without noting that the likelihood of confusion test is sufficiently flexible itself. By the way, you talk about making things up. The Polaroid test, the Steelcraft test, it's all judicially crafted. These tests have to be, because the statute talks about likelihood of confusion, and what judges have to do is figure out how do we get to that? How do we decide whether it's confused? So we got to create some principles. I think you're right about it can't be just commercial products, because then you get into, can you use it in one setting but not another? It can't be just designation of origin, because that doesn't have to do with improper use. I think it's contextual. And I think that you're shaking your head, yes.
Yes, absolutely.
If you look at all of the factors, I call them the Polaroid factors, because you know I'm from the Second Circuit, so I'm most intimately familiar with those.
Yeah.
What they're trying to get at is whether the use of this trademark in this context can or is confusing. And so I see the Rogers test, perhaps not as articulated, but all of the circuits have some form of it, and it's all different. But I see them all doing something where they're saying there are certain contexts of use that are less likely or not likely to confuse. What the Second Circuit said with respect to titles is, when you're talking about a title use, the context of a movie, you can't decide whether it's confusing until you look at the movie and you decide whether or not the movie uses the title in an aesthetically pleasing way. I think they did add something to the likelihood of confusion standard that's not there, because they said it has to have, I don't remember the words, but something greater than just a likelihood of confusion.
Artistic relevance?
Artistic relevance. That may have gone too far, okay? But my point simply is, I would limit this to parity and not to anything else, because parity as a context does ask not all of the Polaroid factors. It asks something very different. And that's what I would limit the likelihood of confusion test to. But I want you to answer these hypotheticals.
Of course.
All right? And I want you to answer them in view of what Justice Thomas said. Assume that I think that there are some uses that in context, on their face, should not require a litany of Polaroid factors with surveys and everything else for a court to be able to decide this on a motion to dismiss or summary judgment. An activist takes a political party's trademark, Animal Logan.
I'm sorry, I missed that last part.
Takes an Animal Logan, a donkey or an elephant, okay?
Oh, elephant.
Yeah, whatever.
I got it.
One of the political party's Animal Logans, and makes a T-shirt where the animal looks drunk, accompanied by a slogan, "Time to sober up, America." And they wear that proudly at a protest or here in court.
Do you want my answer?
She sells these T-shirts on Amazon.
Okay.
The political party gets a consumer survey purportedly showing that 15%, 20, 25, 10, whatever number we make up, okay, think the activist needs the party's permission to copy the logo. So, I'm a judge. I know what I would do. But tell me what you would do. And do they have to go through a full trial under the Polaroid factors to decide this case?
Okay, so, first of all, that's funny. Your example, I'm going to give you that. Second of all, if I could go back to the point about Polaroid, there is the fact that a product, including your T-shirt example, is funny or it has a parody is not relevant. What is extremely relevant is any characteristic.
Is whether the person viewing it would get the joke.
No.
And so isn't that the issue that we're dealing with in confusion?
Well, I'd like to get this answer out. It's not whether you get the joke. You get that somebody other than the brand wasn't making the joke, because that's all that matters. Not ha 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 is not a standard under the Lanham Act. It's whether it's confusing as to source. Now, in your Republican, elephant
well, that's
example,
going back to Justice Jackson's point, and you said it's not only about source. So what else is it about?
Right. Okay. On your elephant example, in terms of if there's a mistaken idea that, oh, well, you had to copy. Okay. First of all, on consumer surveys, they're capturing, for whatever reason, because consumers are dumb or they're confused about the law or just the way they make marketing decisions, surveys are picking up the real world marketplace that a judge who has hindsight bias and is highly analytical is not going to represent the purchasing public. The reason we have surveys in the first place is pretty amazing. In 1948, Jerome Frank on the Second Circuit had a case involving teenage girls' underwear, and he said, you got to be kidding me. I'm a man. Everyone on this court is a man. How am I supposed to know this? Couldn't somebody do a survey? And surveys were born. And that was in 1948. So it's just a little bit rich to trash surveys when the whole point that they came out was to help consumers. Now, on that bit about there's a mistaken perception, it's not a mistaken perception. You do have to get permission if it's confusing. Now, your example on the T-shirts, if there's a survey on 15%, and I also heard in there some sort of implicit thing that 15% was too low. If this court had a rule saying, advocates, please do not have briefs that are likely misleading, and if you want us to say, advocates, that can go up to 50%, because it's okay if only 20% of judges found it deceptive, or even 40%. It has to be more than half. So I think
but that's the basic problem, which is the percentage. At some point, it's a political statement. It has First Amendment rights. And even if 20, maybe even if 75, it's very clear that at a certain point, those people may be wrong on the law. They don't need permission to make a political joke. They don't need permission to make a parody.
You need to get permission if it's a confusing parody. Now, in terms of I do want to get this point out. There are three very important sleek craft factors that bear on the specifics of parody. And the other dog toy case involving Chewy Vuitton, it was a play on Louis Vuitton and Chewy Vuitton. The contrast with that case and this case, I think, tells you everything you need to know about likelihood of confusion. In the Chewy Vuitton case, it was on substantial similarity in marks, the uses in the mark, and is there some sort of dispelling characteristics that says, the definition of a parody is that you have to conjure up enough similarity, but then you immediately simultaneously distinguish and say, but this is not, someone else is telling the joke. And in the Chewy Vuitton case, the court said, I'm immediately struck by how different. Our court said, I'm immediately struck by how similar. There were 9 virtually identical things that were unchanged. In the Chewy Vuitton case, he said almost all the designs were different. In the uses of the markets, in the Louis Vuitton case, Louis Vuitton makes dog products, but they're $1,200. They're complete luxury products. They only sell in boutique stores or in boutiques and department stores. In the Jack Daniels case, Jack Daniels makes dog products and sells licensed merchandise like hats and bar stools and what have you in the same markets that Bad Spaniels was selling its dog toys. And when you have a consumer survey that tells you the consumers didn't get the joke, they could have thought it was funny. And by the way, only 7 people said they thought there was a confusion as to who owned it, who needed permission, and that still left 25% confusion, which is still, a massively high consumer survey. So it is not all the sleek crack Polaroid factors will be relevant. And the other thing I want to say before the government gets up here, for 30 years, what I've been saying is what the PTO has been doing. They've been finding parody after parody, either confusing or not confusing, based on the same thing that this trial court did. It looked at how similar and famous the mark is, and is there something that kind of says, whoa, it's so obvious. I think in the Republicans go around drunk and need to sober up, your average consumer is going to think the RNC didn't do that. But I could go on and on and on. And the other thing I just wanted to say about your aesthetically pleasing, the movie Debbie Does Dallas was not aesthetically pleasing. It infringed a trademark. It infringed someone's property rights, and it was diluting. So the other side wants to talk about the uses they like. They don't want to talk about the pornographic and poisonous things that can be done when you infringe someone's trademark.